Firstly, welcome to this evening's webinar. I'm Nick, who's obviously a barrister at Red Lion Chambers. For those of you who haven't attended these webinars before, the idea behind them was that junior barristers could address issues affecting us in practice, new sort of emerging themes, and we could also tailor it towards potentially a more junior solicitor audience. So although it may seem really formal because I'm in a suit and tie, normally we would have these in person and there would be wine afterwards. So really feel free to relax, like pour yourself a drink, and it is an informal presentation. So I think the expectations may be slightly different. Some housekeeping, we're trying to encourage it as much as possible to be interactive as it was before when we had them in person. So if you want any questions to be addressed, if you put them in the sidebar, in the chat box, Georgia will address any questions relating to her after her talk. We'll then move on to Laura, and she'll address any questions at the end of her talk. And the talk shouldn't be any more than an hour, so you will be released come 6:30. Before we do that, some welcoming news. We now have 4 new pupils who have arrived in Chambers. That's Alex Ben, Sarah Taylor-Wilmhurst, Josh Ellis, and then Nick Fryer. But also even better news as well, we have now got 3 new tenants. And I know many of you may know Tom, Helena, and Sam, but in January this year, they've been taken on. So they're going to be doing the next presentation, so you can watch this space. 2 talks tonight. George is firstly going to be talking about indecent images and technical IT considerations. And then Laura is going to be looking at consent and the impact of intoxication. So quite 2 new themes in relation to sex and sexual offences. But like I said, please try and be interactive as possible, and post your comments in the sidebar. I'm going to duck out now and leave it in the capable hands of Georgia Lassoff. Georgia, is there anything more you need me to say, or good to go?
We're good to go. Thank you so much,
Thanks.
Nick, for that wonderful comparing as per usual. So my talk is about indecent images of children and IT considerations. And Laura will be doing the slideshow for me because I cannot do 2 things at once. Can I have the first slide, please, Laura? Thank you. Yep, this one. So there's 3 main categories of the indecent images of children offences. They are possession, distribution, and what I've grouped as production, taking, and making. Now, you'll see from the slide that these offences originate in 1988 and 1978. So some of you sharp lawyers may have realised that IT has come along quite some way since the 70s and 80s. There are multitudes of IT considerations to be thought of when you're looking at indecent images of children offences. So for the purposes of this short talk, I'm just going to be focusing on a few, and I'm going to be focusing on IT in relation to the possession offences and the distribution offences. I'm not really going to be touching on production, taking, making, as that's a whole nother area. There is quite a lot of literature out there, especially on the making as it relates to IT, and I'm free to answer any questions on that later.
Georgia, can I interrupt? The chat bar has just been made public. It was private and disabled, so now you should be able to post your questions. Thanks, Georgia.
Okay. Can I have the next slide, please, Laura? So for possession, the first possession offence is contrary to Section 160 of the Criminal Justice Act 1988, and it is an offence for a person to have any indecent photograph or pseudo photograph of a child in his possession. So the 2 main cases I want to look at tonight, the first one is the Crown and Porter, and this is where kind of an up-to-date notion of possession was formulated by the Court of Appeal. So in Porter, the Court of Appeal held that a person is in possession of an image in the form of a computer file if it is within his control. If he can produce it on a screen, make a hard copy of it, or send it to someone else. So that's quite straightforward. That's all possession. However, in the case of a deleted image, if a person can't retrieve or access it, he no longer has custody or control of it, and so it is not within his possession. Because any practitioner who's dealt with indecent images will know that on the SFR1, the forensic report, you'll often have the distinction between accessible images and inaccessible images. Now, technically, because the inaccessible, i.e. deleted images, are on the computer, it used to be the case that someone could be found guilty of being in possession of them, even if they were deleted, because, as we probably all know, nothing really gets deleted from a computer ever. So the Court of Appeal over the next couple of years had to decide what they wanted to do with deleted images. So that what followed Porter was the case of Leonard, which concerned deleted indecent images of children found in a temporary internet file on the appellant's computer. So what happens is, if you go on a website with indecent images of children on it, it's possible that your computer will store a cache of those images in a file on your computer. Now, the Court of Appeal said that in Leonard, the appellant wasn't actually in possession of them because the files on his computer would have only been accessible to someone with specialist computer skills or software, and there was no evidence that the appellant had either the skills or the software to retrieve these indecent images from the deleted cache. So that is my IT point number one, deleted images. If your client has been charged with possession of indecent images of children, and you can tell from the MG5 that some are inaccessible or have been deleted, before you consider pleading to those images, you have to ask, does your client have the technical speciality to then retrieve those images? Now, in some cases, it will be very obvious. If they're an IT consultant, probably they would have that ability to retrieve the images. But for the layperson, it's highly likely that they can't. And I've seen it on multiple occasions where the Crown haven't really put much thought into this. They haven't really distinguished on an indictment whether they're charging deleted images in conjunction with non-deleted images. So even if you're going to plead to the accessible images, there is a good case to be made that you should enter a basis of plea to a lot less numerically than on the indictment. Then we have the case of the Crown and Okoro, which is more recent. So the case clarified and affirmed previous case law in relation to possession, and the test to determine possession was set out in terms that the images must be in the custody or control of the defendant so that they're capable of accessing it. That's the Porter point. And then the suspect must have known that they possessed an image or group of images on the relevant device or devices. So knowledge of the content of those images is not required because the statutory defenses deal with that, which I'll come on to later. So this goes on to IT point number 2, duplicate images. Often in these kind of cases, the Crown will charge possession across a variety of devices. So say if your client has a computer that has at least one hard drive in it, then they have a mobile phone, then they have a USB stick and external hard drives. If indecent images are found on all of these, it's, in my experience, the Crown will just charge them all on a separate count. So possession of 500 images on the hard drive, possession of 500 images on the USB. Now, it's really important that you have access to at least the file names if you have a client charged with these multiple counts, because it's more than likely they're going to be duplicate. And as we know from looking at the sentencing guidelines, the number of images you're convicted of really makes a difference to sentence. So I had a recent case where a very young man was charged with possession of around, I think, a couple hundred Cat A and B images and 1,000 Category B. And at the first appearance, which was covered by my wonderful colleague Sam Smart, the police all of a sudden thrust in everyone's face a schedule of offences to be taken into consideration. Now, at that point, the TIC schedule had a lot of information about these images, but there was no information about the actual charged images until the day before the PTPH. On that day, because we pressed for loads more information about the actual indicted images, it was really obvious that they were just the same images that were indicted then on the TIC schedule, because what happened is that my client had been accessing these indecent images of children from a cloud platform. So like a kind of dark web equivalent of iCloud. He had then downloaded them all to his phone. So it's really important that you get enough information from the Crown to figure out if any of these are duplicate or not. Next slide, please, Laura. And then the second type of possession offence is essentially the P-wits of indecent images of children. So it's having his possession any such photograph with a view to it being distributed or shown by himself or others. So it's essentially possession with intent to supply. So the case of Dooley requires that the distribution or showing must be at least one of the purposes of having these images, but not necessarily his primary purpose. So why that distinction was made in Dooley is because the appellant had downloaded all the indecent images from a file sharing website. And what he had done then, and any of you, not that anyone here will have downloaded illegal films or music or albums when they were 14 before, but some of you more daring professionals might know that if you do use a file sharing service, you have the option, and sometimes it automatically sets it to reshare everything that you've downloaded, so it will be in a shareable folder. Now, the Court of Appeal concluded in Dooley that mere knowledge that others could or were likely to see them by virtue of these images being downloaded from the peer-to-peer software and then placed in the sharing folder. So just because the appellant knew that they were in a sharing folder, that wasn't enough. He was only guilty if at least one of the reasons for him putting them in there was to then share them with others. And that's my next IT consideration about this peer-to-peer sharing, because I've seen it where clients have been charged with either the possession with a view to distribute or distribution for having these images in the shareable folder. Now, it's really important to get really clear instructions on this, and also probably in all cases really get a defense expert report, because if the file sharing program automatically places the files into a shareable folder and your client has no idea about this, even if they're then shared with everyone else, that doesn't make out the possession with a view to distribute offence. Next slide, please. Thank you. So that brings us nicely on to distribution. So the Act says a person is to be regarded as distributing indecent photographs or pseudo photographs if they part with possession of it or expose or offer it for acquisition by another person. So obviously giving someone a password to a zip file or emailing in images or sending over WhatsApp or printing an indecent image out and physically giving it to someone else, obviously that will complete the offence. But what about this issue about peer-to-peer file sharing? So the SFR1 will usually say, when your client's charged with distribution, whether or not a file has been fully or partially uploaded. Partial distribution means that chunks or parts of the files has been transferred to other users from the defendant's computer, because the way in which file sharing works, and in so many cases the Crown just do not consider this or understand this, is that file sharing works because lots of users all over the world have this one image. So you have person A with the image, person B with the image, person C with the image, and then person D who doesn't have it wants it. So to speed up the whole process of transferring, D will get little bits of this image from A, B, and C. He won't get the full image from just one person unless only one other person on the network has the image. But until the end user, so D, receives all the parts of the file, it can't be opened on their computer. So it's not actually possible to view any part of a partially uploaded file. The single part, so the partial upload from the defendant to this unknown person, is not viewable or accessible. And it's impossible to tell from the SFR1 whether person D has actually in fact collected all the different pieces to allow them to view the image. So what different RASO teams have done, because there's no kind of appellant guidance on this, on what to do with file sharing. So London North and London South RASO charge partial uploads under section 11C, have in their possession with a view to their being distributed or shown. But other RASO and other CPS regions, such as Thames Valley CPS, my nemesis about this very particular point, charge partial uploads seemingly at random. Sometimes they charge possession with a view, sometimes they charge distribution. Now, I don't think that looking at the definition of distribute and knowing that this is a strict liability offence, I don't think that Parliament could have intended an attempt to satisfy this unless it's actually charged as an attempt. The issue with getting some consistent authority on this is that in my experience, defendants don't really want to be the test case on this. And I mean, you can't really blame them, because if you're saying to a client, you know, we have to accept possession, but we think that you have a good case on not being liable for distribution, but unfortunately this might have to go to a higher court. No one really wants to be that test case in these circumstances. So until we get a case that is tested properly, it really depends on what region charges under these circumstances with file sharing. Next slide, please, Laura. So the statutory defences. So section 162 provides a defence to simple possession, as it were. So it shall be a defence for him to prove that he had a legitimate reason for having the photograph, that he had not himself seen it, and did not know nor had any cause to suspect it to be indecent, or that the photo was sent to him without any prior request. So B and A and B are also defences for the other, so they're also defences for the distribution and the subsection 1B and C from the other act. So legitimate reason isn't really something I'm going to touch on because that's not really technical. Basically, legitimate reason is research, which has a very bad track record of being accepted by juries and the Court of Appeal. I think that guy from The Who or Pink Floyd tried that and didn't work. But also it's for the reason of healthcare and legal contexts. There's also a defense of marriage. So when an adult marries someone of 16 or 17 years old and takes consensual nudes, that is apparently a defense. One thing I will say about that, the one night stands do not count according to the Court of Appeal. So if your client is trying to raise the defense that they were in a relationship with this person and they were 16 or 17 years old, the Court of Appeal has made it very clear that only marriage will provide a defense. Now, defenses A and B, and more defense B, so it is a defense for the defendant to prove that he had not himself seen the photo or pseudo photograph and did not know nor had cause to suspect it be indecent. This raises my last IT consideration, especially for a charge of possession. So just because an image was found on a device and they were accessible, we need to think about whether your client can prove on the balance of probability that they had no idea that the images were there or what they contained. So another wonderful colleague of mine, Zoe Chapman, has recently had a case where this was an issue, and I apologize for completely bastardizing the facts, but I think it's really interesting. So what happened in Zoe's case is that her client was sent images on Kik, which is a messenger platform, kind of like WhatsApp. So on Kik and WhatsApp, what happens is that when you're sent an image and the conversation, kind of a group chat, moves on, the image, one, is stored to your phone, and two, everything. So when you open the application, even if you can't see the messages that have gone before, it will mark them as read. So it's like the blue ticks in WhatsApp. So I'm sure everyone's in loads of WhatsApp groups, including during lockdown. So it's kind of like if you log on or you open a WhatsApp group after a whole day of not being on it, and there's like over 100 messages, you're not going to go scroll back up and read them all. But for someone looking at your phone and the police examining your phone, it will look like you've seen them all. So in Zoe's case, it came down to the Crown accepting that the images weren't readily accessible because they had no evidence that the defendant had actually accessed them, because they were in kind of a folder to which images were automatically downloaded. So in conclusion, I know this has been a whistle-stop tour, but there are so many IT considerations to think about. I think the main point to take from this is that, as is often the case, the Crown relies on police or civilians attached to police forces to be experts. And we've all seen really the SFR ones for indecent images of children. They're really generic. They don't go into detail about where files were kept, why the Crown is saying they're accessible or not, or really the number of them even. So it's really important that when you've got one of these cases, you have to be alive to the technical issues. A basic understanding of how apps work, or even kind of the suspicion about how they might work, can go a really long way and will help a practitioner ask an expert the right question. And I think that in the right case, especially if your client's instructions accord with this, it is worth getting a defense expert report just to kind of unpack what the police are saying. Because the police could say that, yes, all these images are accessible on the hard drive, but if they're not giving the file location, it's impossible to know whether, as in the case of Zoe's client, these images were automatically downloaded or not. So that's all I have to say. I'm just going to look at the chat box. Could you please define pseudo images? Yes, I can. So a pseudo image, I'll just get to my section on this. So a pseudo image can be an image that is generated by a computer, and it can be a cartoon, and it can be any number of things that aren't an actual photo of a child. Yes, thank you, Nick. Nick's just messaged me with a snappy definition. A pseudo photograph is an image made by computer graphics or which otherwise appears to be a photograph. So there is actually a difference between kind of anime and hentai and a pseudo photograph. A pseudo photograph is essentially CGI. So my talk didn't really focus on what is a indecent image of a child, because I simply didn't have time, but there's loads of literature out there. And I think it's a really interesting area. We see so many people being charged with these offences, and there's not really that much appellate authority. I just had another question come through. So it says, are there any other common IT pitfalls you've not mentioned but worth us researching in our time? I think those are the main IT ones. Deleted images, can your client access them? Possession, were they actually stored in a folder that your client had no idea about? And then peer-to-peer file sharing. So just in the interest of time, I'm now going to pass over to Laura, but I'll put my email address in the chat and feel free to follow up with any other questions.
Laura, just before you begin, I will also say that the slides are going to go onto the website, and this webinar is being recorded, so it will be available to go back and re-listen if you weren't able to take notes. And that does not mean you should all leave now, because we're about to hear from the wonderful Laura Miller talking about consent and intoxication.
Hello, everybody. I'm just going to share my slides. If you could give me a moment just to start the slideshow. So what I'm going to talk about today is consent and the impact of intoxication, specifically in respect of sex cases, sexual offences. Can I just do a shout out at the start to Alex Ben, who's one of our new pupil barristers, who helped me significantly in the research. for this talk, and I know that he is one of the participants who is watching the talk this evening. So thank you very much to him for his time and the efforts that he put in to assisting me with this talk. The slides that I've compiled are quite full, so most of what I'm going to say is contained within the slides, and as Nick's already said, they are going to be put online, so don't feel like you have to take down notes of what I am saying. The slides will be available, and also at the end of the talk, I'll put my email address in the comments box, and if anybody would like copies of the authorities that I referred to, I'm quite happy to email them across at the request. Just send me an email and I can send them over. Effectively, I'm going to go quite quickly because there's quite a lot to say in respect of the impact of intoxication on the issue of consent. And as Nick has said at the start, these talks are very much designed for the more junior members of both professions, paralegals, case handlers, solicitors, and the junior bar. So at the start, I just wanted to go through the definition of 3 sexual offences, so rape, assault by penetration, and sexual assault. So definition of rape, defendant penetrated the vagina, anus or mouth of the complainant with his penis, and that the complainant did not consent to the penetration. The mental element of rape is that the penetration must be intentional and that the defendant did not reasonably believe that the complainant consented. And it is worth saying that it's probably obvious, but it's worth saying that the issue of consent by the complainant and a defendant's reasonable belief that the complainant consented, whilst the factors for each may overlap, they are 2 distinct offence criteria, and they must be looked at separately when you are either prosecuting or defending cases of rape, assault by penetration, and sexual assault, because it applies to all 3. So assault by penetration, a definition of assault by penetration is that the defendant penetrated the vagina or anus of the complainant with a part of his body or anything else, and the penetration was sexual. And I've defined what sexual is under the purposes of the legislation on that slide there as well. In terms of assault by penetration, there is also the fact that the complainant did not consent to the penetration. The mental element, again, is that the defendant penetrated the complainant intentionally, and again, that the defendant did not reasonably believe that the complainant consented. And as with all 3 of the offences that we are just going through now, the reasonableness of the belief depends on all of the circumstances of the case, including any steps that the defendant took to ascertain whether the complainant consented. In terms of sexual assault, the defendant must be proved to have touched the complainant. That touching must be proved to be sexual, and it must be proved that the complainant did not consent to the touching. Again, the mental element is that the defendant must have touched the complainant intentionally, and that the defendant did not reasonably believe that the complainant consented to the touching. I should have said at the outset that the offences that I am going to touch on today only relate to the Sexual Offences Act 2003. Now, consent. What is consent? Well, consent is defined by section, or it's dealt with by section 74 of the Sexual Offences Act 2003. And the general position is that a person consents if he agrees by choice and has the freedom and capacity to make that choice. Now, this is really the key principle that we are going to be looking at today, because the issues with intoxication often go to the complainant's capacity to consent and whether or not the complainant had the capacity to agree by choice, to make the choice to participate in the sexual act. Just by way of information and comment, that the issues of consent should normally be left to the jury, and it should only be in clear cases that a judge should conclude that there's no evidence on which a jury could properly convict and accept a submission of no case to answer. And that was the case of the Crown and Ali in 2015. So where consent is an issue, it usually should be left to the jury. Now just looking at voluntary intoxication, which will be probably the usual type of intoxication that it is looked at in terms of consent and intoxication in respect of sex cases, for reasons that I'll come on to in a moment. But the general position, again, it is simply applying Section 74 of the Sexual Offences Act 2003, and voluntary intoxication does not in itself preclude consent. However, whether or not the complainant had the capacity to consent will really depend on looking at all of the circumstances of a case. How much the complainant had to drink, what they had to drink, the effect that it had upon them. And it's important to know that in the case of the Crown and Brie, that consent was said to may evaporate well before the complainant becomes unconscious, but that each case must be considered on the particular circumstances of the allegation before, or the circumstances before the court. Now, just moving quickly on to involuntary intoxication, there are some presumptions, which is Section 75 and Section 76 of the Sexual Offences Act 2003. The only one that I have referenced in these slides is Section 75, which says that if in the proceedings for an offence to which the section applies, it's proved that the defendant did the act, that any of the circumstances specified in subsection 2 existed, and the defendant knew that those circumstances existed, the complainant is to be taken not to have consented to the relevant act unless sufficient evidence is adduced to raise an issue as to whether he consented, and the defendant is to be taken not to have reasonably believed that the complainant consented unless sufficient evidence is adduced to raise an issue as to whether he reasonably believed it. The reason that Section 75 is applicable to involuntary intoxication is that subsection 2F provides that one of the circumstances to be proved under Section 2 is that any person had administered to or caused to be taken by the complainant without the complainant's consent a substance which, having regard to it, was administered or taken, was capable of causing or enabling the complainant to be stupefied or overpowered at the time of the relevant act. That would apply to involuntary intoxication. And just a note at the bottom there, that just because one of the presumptions is triggered, it doesn't reverse the ordinary burden of proof in respect of such cases. Now just moving on to capacity. The Sexual Offences Act 2003 does not define capacity. And when summing up, the judge in a case should give the jury some assistance as to the meaning of capacity in circumstances where voluntary intoxication has significantly affected a complainant. The judge may need to raise some of the following points. So it's something that advocates do need to be aware of when prosecuting and or defending sexual offences. So when discussing the legal directions, the judge is reminded, if they haven't already done so, to cover the relevant points. And they may need to cover if the consumption of alcohol or other drugs has caused a complainant to consent to an activity that they would ordinarily refuse. That is consent in spite of any subsequent regret. There's no duty to phrase it as a drunken consent is still consent, so long as the judge addresses the important points. But intoxication can affect, as I've already said, a complainant to the point that they no longer have capacity to consent. And as I've already said, each case must be dealt with on their own facts. And the lack of capacity can arise before a loss of consciousness. Capacity, and the judge should not address capacity if it's not a live issue in the case. I've just popped in the next slide a section of the Crown Court Compendium, just setting out some what may be helpful information if you are in a trial where consent is an issue. Because the Crown can phrase their case, as will be obvious, in an alternative that the complainant lacked the capacity to consent and that he or she did not consent. And if the Crown have phrased their case as an alternative, the jury should be given directions about each alternative. They should not be directed about the lack of capacity if it's not a live issue in the case. Really some quite interesting academic material that I've included in the next slide. The Home Office setting the boundaries, reforming the law on sex offences, which was in 2000. The report endorsed the Law Commission's recommendation as to the meaning of capacity for the purposes of non-consensual sexual offences, and said that a person should be regarded as lacking capacity to consent if at the material time the person is, by reason of mental disability, unable to make a decision for themselves on the matter in question, or the person is unable to communicate their decision on that matter because they are unconscious or for any other reason. A person should be regarded as being unable to make a decision on whether to consent to an act if he or she is unable to understand, one, the nature and reasonable foreseeable consequences of the act, and two, the implications of the act and its reasonably foreseeable consequences, or being able to understand he or she is nonetheless unable to make a decision. And mental disability was also defined by the act. So that definition would of course also include if somebody was so intoxicated that they had lost the capacity to be able to consent. I just want to go on, because one of the factors which plays a part in cases, usually in respect of consent and intoxication, is Section 41 of the Youth Justice and Criminal Evidence Act 1999. And Section 41 applies in Crown Court trials and Magistrates Courts committals, application to dismiss following a notice of transfer, Newton hearings, and the hearing of appeals. Section 41, in fact, only applies to the defence and doesn't apply to the prosecution. Now, Section 41 I've set out there for you over a couple of slides, just so you have it. But effectively, the cross-examination of complainants in sexual cases about their previous sexual history is very strictly limited and cannot be undertaken without the leave of the court. And the court will only give leave if the applicant of the defence can show that either subsection 3 or subsection 5 of 41 of section 41 applies, and that a refusal of leave might have the result of rendering unsafe a conclusion of the jury, or as the case may be, that the court on any relevant issue in the case, because obviously it applies to the magistrates as well as the Crown Court. So it's not simply in jury trials that section 41 will apply. And subsection 3 applies if the evidence or question relates to a relevant issue in the case. A is if that's not an issue in relation to consent, or B, it's an issue of consent and the sexual behaviour of the complainant to which the evidence or question relates is alleged to have taken place at or about the same time as the event, which is the subject matter of the charge against the accused, or it's an issue of consent and the sexual behaviour of the complainant to which the evidence or question relates is alleged to have been in any respect so similar to the sexual behaviour of the complainant, which according to the evidence adduced or to be adduced by or on behalf of the accused took place as part of the event, which is the subject matter of the charge against the accused, or to any other sexual behaviour of the complainant, which according to such evidence took place at or about the same time as that event. That similarity cannot reasonably be explained as a coincidence. And subsection 4, you cannot raise section 41 simply to impugn the credibility of the complainant. Subsection 5, and this subsection applies to question or evidence if it relates to any evidence adduced by the prosecution about any sexual behaviour of the complainant, and in the opinion of the court would go no further than necessary to enable the evidence adduced by the prosecution to be rebutted or explained by the defence. And I should say that any evidence that is sought to be relied on under section 41 must relate to specific instance or instances of alleged sexual behaviour, and cannot just be simply generic conduct or speculation. And just so it is clear, a sexual offence includes any offence under Part 1 of the Sexual Offences Act, and offences outlined in section 62 of the Youth Justice and Criminal Evidence Act, and cases alleged to have taken place before the enactment of the Sexual Offences Act 2003. I've just gone through, just for completeness really, the meaning of sexual offence, so that it's included within the slides. The meaning of issue of consent, the term issue of consent means any issue as to whether the complainant in fact consented to the conduct constituting the offence with which the accused is charged. It does not include any issue as to the belief of the accused that the complainant so consented. And as I said earlier, those are two distinct criteria for the alleged offending. The first being whether the complainant consented, and the second separate consideration being the mental element, one of the mental elements of the offending, in that the accused reasonably believed the complainant to have consented. And it's very important, as I said earlier, not to merge the two together, although you are likely to be relying on similar facts for both. They need to be considered separately, and they are very distinct criteria. in terms of these offences. Now I just want to go on to some relevant case law. And the first few cases that I'm going to talk about are in respect of the application of Section 41. And then I'm going to go on to talk about a couple of cases, notably the case of Ched Evans, which did relate to intoxication and consent. And I will go as quickly as I can because I can see that we are fast approaching 20 past 6, got 10 minutes left. The first case is the Crown and G in 2016. The appeal was dismissed and the conviction upheld, and it was held that on the facts, there was no sufficient chronological nexus between the alleged rape and the alleged consensual activity to make the behaviour probative. And it was confirmed that Section 41 is a very high threshold. Section 41(3)(c) does not require striking similarity between the alleged conduct and the previous sexual conduct that the defence want to rely upon, but that there must be relevant similarity to demonstrate necessity to avoid unfairness to the defendant. And I've just put in there a short, succinct synopsis of what the case was about. So at trial, the prosecution alleged that the defendant had vaginally raped the girlfriend of his brother, and the jury found him guilty of rape. The main issue was whether or not the appellant's evidence of a history of consensual sexual behaviour between the complainant and himself was sufficiently similar for the purposes of Section 41(3)(c). And it was deemed that the threshold was not a striking similarity, it's a relevant similarity, and that's at paragraph 10 of the judgment. Now, the next case, the appeal was dismissed and the conviction upheld. It was held that the trial judge was entitled to refuse to admit proposed evidence of the complainant's behaviour in relation to oral penetration of other people, as it was not so relevant that its exclusion would create unfairness. And the judge was entitled to rule that the sexual behaviour was not sufficiently similar to satisfy Section 41(3)(c). Again, a short synopsis of the facts of that offence. On appeal, the appellant sought to rely on Section 41(3)(c) to admit proposed evidence of previous instance of oral penetration of other people. And in effect, in respect of the first instance, the court held that the judge was entitled to reach the conclusion that the similarity was not so great that it could not reasonably be explained as a coincidence. But to the second incident, which post-dated the offence at trial by around 2 years, the judge held that, the court held that the judge was unquestionably entitled to reject the application. That application in particular, the court commented that it seemed to have tested the very rationale for enacting Section 41 in the first place, which was, of course, to give a protection to those persons who alleged that they are the victims of sexual misconduct, so that they are not effectively, cross-examined heavily without good reason on previous sexual conduct during the course of the trial process. Now, just because of the time, I just want to skip through to Section 41 as it relates to intoxication. And as I indicated before, that the case of Ched Evans. Ched Evans was a professional football player who played for Sheffield United, I believe. And he, along with one of his colleagues, was accused of raping a girl at a hotel. She was described by the hotel receptionist as being heavily intoxicated, and she went into the room with Clayton MacDonald, who was the co-defendant of Ched Evans. And the hotel receptionist was so concerned about her, he actually went to the room after Ched Evans had come in and asked for a second key and listened at the door, presumably to make sure she was all right, and realised that they were having sex. And Ched Evans was prosecuted along with Clayton MacDonald in 2012. He was convicted of rape and Clayton MacDonald was acquitted, and he was sentenced to 5 years, and he served the custodial part of that sentence before being released. He made 2 appeals to the Court of Appeal. He appealed unsuccessfully, both on paper to the application to the single judge, and also renewed his appeal to the full court, which was rejected. He then went via the CCRC, who referred the matter back to the Court of Appeal, and his second appeal was successful. Another man, so on the day that he was convicted, another man telephoned the police and indicated that he had had sexual relationships with the complainant a couple of weeks after the alleged incident, and he found it odd that she would have been engaging in that behaviour if she had been raped only a couple of weeks before. He provided a number of witness statements to the police, in which he detailed how he had met up with the complainant while she was drunk. On the first 3 occasions, they had just slept in the same bed together, but engaged in non-penetrative sexual activity. He then gave a second statement. All of the statements were given to the defence, in which he described that on a 4th occasion he had had sex with the complainant, and he described her undertaking certain behaviours, for example, taking the lead in effectively undertaking penetrative sex from behind, and to have used the same phrase that had been alleged by Ched Evans. And that was very similar to the account that Ched Evans had given both in a voluntary police interview and also at trial. And by the time it came before the CCRC, there was another man who had detailed sexual activity with the complainant approximately a year before the trial of Ched Evans, but certainly before the allegation of rape was made against him. And he too detailed very similar actions of the complainant whilst having sexual relations whilst intoxicated. And that was in respect of both her requesting certain sexual positions and also the words used by her, which were not identical, but were similar to that, or to those indicated by both the man who had contacted police on the day of the conviction and Ched Evans himself. And Kieran Vaughan QC and David Emanuel, who were the barristers representing Ched Evans at the Court of Appeal, they relied on Section 41, and they focused on the similarity of the complainant's sexual behaviour and the cumulative effect of the similarities of the account of Ched Evans and the 2 other men. It is worth noting that one of those men was an associate of Ched Evans himself, and the third man did not know Ched Evans or the second man, but that the account had been in the public domain. But the Court of Appeal, in determining the case, focused on the ultimate question of the admissibility of the evidence at the initial trial, and reasoned that because the complainant couldn't remember anything, and it had in fact never said she had been raped, she just woke up in a hotel and she didn't know what had happened to her, which is why she went to the police. And she in fact did not say she was unable to consent either. But because she could not give an account of what had happened, they said that without being able to rely on the character under Section 41, Ched Evans would have effectively only be able to rely on his own account. And they allowed it in order to, under subsection 5, to rebut the evidence of the prosecution that the complainant would not have been capable of participating in the way that the defendant and others had described. It's worth noting that although this shows how Section 41 and previous sexual conduct can be used to rebut the prosecution presumption where intoxication is an issue, intoxication going to memory loss and memory issues in respect of the complainant. But it should be noted that the Court of Appeal were very careful to note that the case of Ched Evans may well be a rare case, and flagged that they had a considerable degree of hesitation, and noted the importance of avoiding intrusive and unnecessary questioning about a complainant's sexual history. Ched Evans was retried at Cardiff in 2016, and he was found not guilty, and there was a lot of media interest in the case. He was represented by Judy Khan QC, and I certainly remember the time when this case was in the news, when effectively all of the evidence and the cross-examination, evidence in chief, the cross-examination was literally being released verbatim on Sky News. So there's a lot of interest in the case, and according to news reports, the jury took about 2 hours to acquit him.
Laura, do you mind if I interrupt you there, because we're coming to the end of the time, and I know it's hard to focus on time and give such a good presentation. There's not any additional questions in the box, which means, well done, you're all scot-free. Although, as stressed, people can still email the recordings online along with the slides. Thank you very much, Laura and Georgia, for giving the webinars, and thank you actually for everyone attending. We had at some stage over 65 people, which is amazing. Few things. Firstly, Tom and Sam are giving the next talk in March, so watch this space, and their topics are going to be released next week. Like we said, hopefully whenever circumstances are less COVID-ish, we will go back to doing it in person in Red Lion whenever that's allowed, and hopefully that will allow us to meet some of you guys, socialize as well over a glass of wine or some beer or a non-alcoholic beverage. Zoe and I did a talk last year that is also that was the first of this series for this year, and that is also online. Mine was on NRM. The law has slightly changed, and there's an update coming in the next week or so on that, and it will be an add-on to that webinar, so keep an eye out for that too. Not to do a shameless plug before I end, but apart from that, unless there's anything else, Laura, Georgia, Joe, that anyone wants to add?
Nick, can I just say, I've put my email address just in the chat, so if anybody would like any of the case law and the rest of the slides that I didn't get to, will be obviously going up on the website. And
that might be quicker than waiting for it to get up, but it should be up in the next few days. Also, thanks to Alex as well, who was helping Laura out. And everyone, hopefully see you soon in person, but have a nice evening, and thank you for joining again. Bye.